Salama sana mzee.
Sawa.
This is my lawyer.
Oh, hi. How are you? Nice to meet you. Tell us why you are here today?
Yes, yesterday the prosecution filed an application.
Msamiati anaendelea. Msamiati anaendelea. Ako sawa tu. Hiyo haina bahati. Yangu ilikuwa off time.
Orally on the following grounds, mainly as summarized. Number one, the respondent had not committed a known offense, rather he exercised his rights in accordance with the Constitution. Number two, no compelling reasons had been adduced for detention of the respondent. Number three, the provisions of the law as cited in the application were erroneous. Number four, police had already obtained the requisite evidence from the respondent in terms of his laptops and mobile phones. 5, accused rights under the Constitution were being infringed for his continued detention. And 6, the respondent had been previously incarcerated and released on bond in similar circumstances. I have considered the following. Number 1, the provisions of Article 49, Article 25, Article 29, Article 132, Article 50, and Article 159 of the Constitution as referred to by parties. Number 2, I've also considered all other laws as referred to by the parties, that is the Criminal Procedure Code, Computer Misuse and Cybercrime Act, where interestingly, as I researched, under the Petition 206 of 2019, that is BAKE versus AG 2020, Justice Kamau held that the act was valid and dismissed the said petition. The other thing I've considered is the Constitution. 5, the case that was cited by Mr. Dumbi. Maybe I should give you the full citation. I did some research. Sudi Oscar Kipchumba versus Republic 2020, EKLR, which I'll discuss later. I also considered a precedent that was provided by the state, Republic versus Joktan, Mayande, and 3 others, 2012. So in my determination, I have considered the arguments by parties in open court, and I'm persuaded to look deeply into the law. In the first case of Sudi Oscar Kipchumba, the matter was before the courts, and the person, the applicant, is a member of parliament. He had been alleged to have committed several offenses, which included hate speech, assault to police officer, possession of firearm, for, offensive conduct, and resisting arrest. The said MP had been placed in custody for 7 days before going to the High Court and had approached the High Court for a revision of the said orders. I've looked at the law that was given by the state, that is Joktan Mayande. The issues at hand in that case are that the 4 accused persons had already been charged in court and had been denied bond and approached the High Court for revision of bond terms.
Your findings, except I would like to apply that Your Honor, being clothed with the jurisdiction and authority to review or revise your ruling, they consider 2 things. One, having dismissed the application in its entirety, then there being no charge against the respondent, then the bail, the cash bail you have ordered to be posted is somewhat in contradiction to the order dismissing the application in its entirety. To reconsider that and revise it and perhaps replace it with an order that he is released unconditionally unless he is charged. Second, in the event that that prayer doesn't find great favor with you, considering this period of corona, that for the last, this is the second year in which we are not really doing business is going down, the economy is suffering. The amount of money in cash bail that you have asked to be posted is completely out of reach of the respondent. And we invite you, especially on account that you made the finding that the block the accounts used by the respondent, that amounts to a correct finding that he from 500,000 to either a free loan of the same amount, that is personal cognizance of that amount, or 50,000 shillings cash bail. As we speak, none of us is making earning a living. We are living hand to mouth really, except for those who, like my colleague here, are in government employment.
He does not have proof.
Unless you are doing pro bono work for the state. So I very humbly and most respectfully ask that we reduce that cash bill to about 50,000. We will do some arambe here and see if we can raise it. 500 shillings is as good as detaining him really. And something I needed a clarification, probably I didn't get properly, is this daily reports. You said daily to report daily to the investigating officer. Now there is a problem. If he is unable to raise the 500,000, he will be in custody in prison. And therefore, there will be fiscal difficulty, actual difficulty of visiting the IO every day. And that will put him in a situation where he will be in default contempt. And that will escalate a bad situation and make it worse. So perhaps if you revise your bail conditions so that he is able to meet them, we can then see about this reporting. And perhaps daily reporting to the IO is again difficult for 2 reasons. One, we don't know the IO's schedule. 2, there is COVID protocols from the Ministry of Health, which seeks to reduce as much as possible physical contact. Whereas the IO is able to perhaps make arrangements for social distancing, but that escalates the opportunistic nature of the COVID virus. Either he might get or he might distribute to the officers. So perhaps considering the nature of investigation regarding social media, because this is not a question of theft or murder, social media, they can investigate. Internet never forgets anything. You can't delete things and they disappear. Their investigation is actually virtual based. So they, in my very humble and respectful submission, they don't need his physical presence to continue investigating unless he's going to be compelled to be talking, and therefore, again, I don't know to what the
Counsel is asking for a bit too much. Your ruling did not say that we do not have a case. Our application was in respect to detention days, which has been declined. And that does not mean that the state does not have a case. We came under a known law, which the court has appreciated. And therefore, your ruling clearly states that we charge the respondent within a reasonable time, which we shall do. And for counsel to ask that reporting to the police daily for 10 days is too much. Your Honor, we were seeking for 10 days and 14 days, and the reason why we sought for 14 days, we had a reason for it. So it is not too much for the respondent to report daily at the police station for the next 10 days. His liberty has not been curtailed, and there is no evidence that COVID-19 regulations are not going to be adhered to. And in case they are not adhered to, they have the liberty to come and report to the court. As for the cash bail that has been awarded, has been given, Your Honor, I believe the court has made a determination considering the nature of the offense, and as you rightly put it, Your Honor, the public opinion that it generates, which affects the entire country. I find it is in orders, and I leave it to court to consider the same. Otherwise, we're okay with the orders that the court has granted.
That there is no offense. So we cannot presume that there is an offense for which he will be charged today, as she is promising that they will be charged. So that is being presumptuous. Secondly, asking the respondent to be reporting to the police, the investigating officer daily, means that he takes away his opportunity to make a livelihood elsewhere. So that he stops doing other business to attend to the investigating officer who is investigating something that is on the internet. And the respondent does not control the internet. His liberty is actually taken away by the very fact of telling him, don't do anything else, come to the police station. The fact that what is alleged to have been stated by the respondent on the internet, and it has influenced or has created a public opinion or public response, that public response, and therefore it's not criminal. So when my colleague says, considering the nature of offense, the nature of offense has not been disclosed because there is no charge. the investigation is not complete, so there is no offense. So it is improper for us to say we are now referring or discussing the nature of offense, yet there is no offense, yet it is closed. Regarding my colleague's response to the request to reduce the bail, the cash bail, I think my colleague says she has, I'll ask her to lend me some. So I would request that indeed.
For clarity, the reporting of the respondent is to assist in investigations. The purview of those investigations, including where to report, is a discussion between the investigating officer and the respondent. They could meet anywhere they so wish, and as citizens, they should follow COVID-19 protocols. So it does not limit them to meet in the police station. They can meet anywhere. Number two, in respect to the public opinion created by these investigations, I find that the cash bail granted has considered all the outlined policy directives regarding bond being granted. It is therefore reasonable. Number three, for clarity, should the respondent be unable to raise the bond terms issued, he shall be detained by the investigating officer at Central Police Station until the mention of the case. Number four, certified copies of the typed ruling to issue to parties at cost. It is so ordered, right of appeal of 14 days. Thank you for your time. Today. Yes.
If we have met that objective, and then she says, on our submission, that money, or whether he has supporters who may be able to raise that money, so it's out. But certainly, we are going to approach the High Court to review and alter this, and probably direct this magistrate on the correct position of the law.